Welcome to SSI Meetup. Today we will be talking about the impact of GDPR on blockchain and self-sovereign identity. And for this, we have Silvan Jongerius with us. We met recently at a presentation in the Netherlands for the Ministry of Interior of the Netherlands. And he gave a really nice talk there. And because of that, I invited Silvan to join us today and look really forward to share this for the whole SSI community. For any of you that came recently to Rebooting Web of Trust in Barcelona, I highly recommend it. It was my first Rebooting Web of Trust, which I really loved. And I think it's a great community to learn about SSI and the future of identity. So I really recommend it for everyone. And if anyone who was there is here today with us today, you're really welcome. It was great to meet you in Barcelona. And I look forward to see you in the next location, which will be somewhere in Europe in September. If we go to slide number 2, let me briefly explain what this is about, what we're doing here at SSI Meetup. Basically, what we're trying to do is to empower global SSI communities, and we try to just to be open for everyone who's interested. And open for everyone means anyone who comes from a company, maybe from a community or any other kind of organization or person who's interested in SSI. And we share all the content in this SSI community with the Creative Commons by share alike license, which basically means that all the content we're sharing here with you today, for example, this presentation that Silvan will be giving, he will be as generous as all the people before have been. You will be able to use the Google Slides to build up the presentations you want to build up in your local communities. And the only thing you will have to do is to credit Silvan and TechGDPR in this case, and SSI Meetup, that you found this information here and that you took it from here, and then you will be able to use it. So after this presentation, I'll be sharing in the same blog post the recording of the whole presentation and access to the Google Slides and access to the SlideShare deck also, where you can check all this out. So if you have any questions during the presentation, please bring them up in the question system you have. Just type them in and I'll be bringing them up to Silvan. And if not, we can make questions at the end too. And Silvan, the floor is for you, and thank you very much for joining us today.
Thank you so much, Alex. It's a real pleasure to be here. Let's see, where's the first slide to start with? I think indeed I'm just going to dive right in. Just a little bit about myself and what we are doing with TechGDPR, just to give you some background on it. It's basically we are a boutique consultancy company based in Berlin, in Germany. And we do GDPR for deep tech, so blockchain, AI, IoT, and related technologies. And the things that we do for our customers, basically around a discovery workshop, do data mapping, we help with assessment and report, we are DPO as a service. We do privacy by design consulting, which is for us one of the more interesting things, helping in the design stage of a product to build something that is actually privacy friendly, and that is what we believe can make probably the biggest impact. And we also do some training. And one of the interesting things that I'd like to share with you is that we did a report for Zcash last year, and that was actually featured in Forbes at the end of January. So we analyzed how shielded payments are actually pretty much out of scope of GDPR and could, through that mechanism, comply with the GDPR. Right. The other thing that I do is around BerChain, which is a community in Berlin. And what I mean with community, this is a collection of the main players in blockchain scene. We have a Slack channel and some other some regular events, etc. And what we do, for example, is so this is what we did end of January, is where we connect the community with politicians, where we had different speakers on stage, including the State Secretary for Interior and Kingdom Relations of the Netherlands and the Permanent Secretary of State in Berlin as well. Yeah, so that's a little bit about what we do in that regard. But I'm of course here to talk about something else, and that something else all starts with a little bit into privacy. So looking at privacy, it's defined as a state in which one is not observed or disturbed by other people, and being free from public attention. And that is also anchored into the European Convention of Human Rights in Article 8.1, where it said that everyone has the right to respect for his private and family life, his home, and his correspondence. Now, what is the thing about privacy, and how does that relate to self-sovereign identity? But first of all, I'd like to talk about the information asymmetry that we have, and why privacy is important. Because if we look at the situation around us, we see that corporations and governments have a lot of information about us, but we actually don't have a lot of information about them. And privacy and the right to privacy is actually there to help us gather more of this, or understand, or basically build a better defense mechanism against these systems. And that is why privacy is so important. So to basically be able to live our lives in privacy without being monitored constantly by governments and corporations, etc. And this is our kind of like last line of defense here, right? In 2010, Facebook stated that privacy is no longer a social norm. And that is, of course, kind of worrying. However, in 2008, they came back with a big stage presentation with Mark Zuckerberg on stage, going into the subject of data privacy with the words written right behind them in bold Facebook type. And even in 2019, they have announced that they are even researching blockchain-based identity solutions, right? So this has come a long way, and with this, I'd like to illustrate that there's a bit of a shift going on, where in 2010 Facebook really had the feeling, well, this is no longer a social norm, and right now this is on the top of their statements and presentations. And also Giovanni Buttarelli, the European Data Protection Supervisor, said there might well be a market for personal data, just like there is tragically a market for live human organs. But it does not mean that we can or should give that market the blessing of legislation. And this is the highest body, the highest entity in Europe in terms of data protection. So a very, very serious statement from a very serious person. And that kind of like leads me into the topic of the GDPR. And the GDPR indeed does take this very, very seriously, and indeed make sure that in any kind of situation, the privacy and the privacy rights of natural people are safeguarded, right? So. And why is it so serious, or how is it taken so seriously? It's mostly through the fines and the risks of non-compliance. So you probably all have heard about up to 20 million or 4% of annual worldwide group turnover fines that can be issued for non-compliance to the GDPR. And this is whichever one is higher. But there are also disclosure requirements. If you suffer a data breach as a company and data does get lost, first of all, you need to notify data protection authorities, which may then again impose some fines if you haven't taken the necessary precautions, or if you have been neglected about personal data. But there could also be the order to stop processing data, which can kind of be seen in a data economy as a possible corporate death sentence, depending on what you do. So I'd like to go a little bit deeper into the GDPR and like make you understand first of all, the basic principles, and also how it relates to, first of all, blockchain, and secondly, self-sovereign identity. Principles of the GDPR are 7 main principles, and I think these are important to understand to also understand how the rest of the regulation works, right? First of all, the data needs to be processed in a lawful, fairness, and transparent way. There needs to be a limitation to the purpose, so data can only be collected for a predefined purpose. There's the principle of data minimization, where it's basically been ensured that that only the data that is required for a certain purpose is being collected. The data needs to be accurate. It cannot be by default stored for an indefinite amount of time. So there would always need to be a certain limitation on that. For example, X years or until after an event, right? It always needs to be defined until when data is being stored. The data should be stored and processed with integrity and confidentiality, and there's the principle of accountability, which is especially like interesting under the GDPR, where basically anyone processing data or controlling or collecting data, to be more precise, is actually being held accountable for taking the right technical and organizational measures. And this is basically approached from a risk base, right? There is the likelihood of a data breach happening, and there's the severity of a potential data breach. And based on such a matrix, data controllers, the ones that are actually collecting the information, are required to make an assessment and to understand, okay, what kind of measures do I need to put in place to protect this data that I'm dealing with. The scope of the GDPR, it's about natural persons in the EU, and I like to stress this because there's a lot of misconception about, is it about European residents or is it about European citizens? But it's actually about people on EU soil. So that is important to understand. With a small example, if an American citizen comes to Europe and rents a car over here, he's very well covered by the GDPR. If I, as a European citizen, would go to the US and rent a car over there for that specific activity, I am not covered by the GDPR, even though I'm a European citizen and resident, but that doesn't cover me if I'm outside of the EU, per se. It is also about personal data, and I'll get a little bit deeper into that later on. And it's also specifically also about pseudonymized data, but not anonymized data. And what is pseudonymized data? That is the data that would be personal data with an extra piece of connecting information. Think about separating data in a database in two tables. One of it is not per se personal data, but it can be linked to a person with a certain ID. So, and then that ID could be a login name or a pseudonymous email address or even a global user ID or whatever it is that you're using. That is still being considered pseudonymous data. And just to relate that back to blockchain, even a wallet address is generally to be seen as pseudonymized data, not anonymized, so still in scope of the GDPR. There's one exception, and that is household use. If you want to write Christmas cards to your friends and family, that is all fine. That is not something that you need to consider the GDPR for or write a privacy policy for. So what is personal data, right? And I think the best way to answer this question is to say, like, okay, it is personal data at the moment that one person can be singled out. And I like to explain that through a little example. Because it also includes metadata and behavioral patterns, right? So if you look at metadata that can reconstruct patterns leading to personal data, then we specifically can, for example, have a look at movement patterns, location data as well, where there may be the case that every Friday morning I go to the bakery and buy a bread, and afterwards I always go to a nearby cafe and drink a coffee. If that is a usual pattern, that will show up in my payment details on my debit card or credit card, and someone could basically just stand outside of the bakery and see who's walking towards the cafe down the street at a specific given point in time based on that specific pattern. And so already these two payment points could constitute personal data. And I think this is also important with the notion of self-sovereign identity and its use cases, right? Then looking at large data sets that basically have a specifically high risk of leaking metadata. If we look at many of the open data sets that are out there, there may well be relatable patterns that we cannot find yet, but with letting loose some artificial intelligence or other analysis on such large data sets, there may well be a way to generate personal data or to basically find personal data points in there. And location data specifically can help constructing whereabouts that can lead to identification, as previously explained. Thinking about what is actually a personal data breach. So by the definition of the GDPR, we're looking at a breach of security leading to the accidental or unlawful destruction, loss, alteration, unauthorized disclosure of or access to personal data transmitted, stored, or otherwise processed. So it is not only disclosing of data to someone who shouldn't have it, also under the GDPR, the destruction, loss, alteration is definitely seen as a personal data breach. And a personal data breach under the GDPR is generally reportable, right? So in terms of breach and notifications, if there's a risk to the freedoms and the rights of a natural person, we need to notify authorities within 72 hours. And if there is especially high risk, again, determined by such a risk matrix, we would also need to notify the affected data subject. And both of these things can, of course, for us as a company or an organization, lead to a reputational risk. If we need to send 10,000 customers that we lost their data, that's not going to reflect very well on us. It may also be all over the media the next day, right? The other interesting or thing that you would need to look at for understanding the GDPR and the rules, especially once we start looking at the blockchain side of things, is the controller and the processor. And the GDPR is very specific about it, has very clearly defined roles. The controller determines the purpose and the means of processing of personal data and is normally the entity that is actually collecting the data. The processor processes personal data on behalf of the controller. Now, these definitions are very important. It's also the processor can only do this on specific written instructions, so that needs to be very clear. It may well be that actually the processor is the party that first touches the data. Think about Typeform or Google Forms that collect data on behalf of an organization. That is still a processor role, because the purpose and the means of that collection is defined by another entity, usually the company that actually will use the data later on. Yeah, so this separation is actually very important. The natural person under the GDPR is referred to as the data subject, just to make sure that you have this vocabulary as we go down this rabbit hole of data protection, privacy, GDPR, blockchain, self-sovereign identity, etc., etc. The GDPR also knows a few legal bases for processing. That means you will always need to argue for a specific legal base that you are using for the collection of the data, and that could be consent. You could collect consent from someone as a legal base to process information. Could also be the performance of a contract. Once you have a contract in place and you need to perform that contract, you need to process data for that purpose. That may well be a good legitimization of data processing. There is something known as a legal obligation. For example, if you need to comply to tax law and for that purpose keep your invoices for 10 years that also contain limited personal data, that is a legitimate way of keeping your data. Then there are two that are more exercised by public entities, and in medical area, the protection of vital interest of the data subject, or a task in the public interest or as a public authority. So that's not too interesting to look at for most technology slash private company situations, but the last one, legitimate interest, actually is. if you as a company can actually claim that you have a legitimate interest for processing data that is not overruled by the interest of a data subject to his or her privacy, then you may actually claim that you have a legitimate interest for processing that data. And one good example of that is processing or the use of server logs. For example, if you run a server, web server, and that server keeps logs for a reasonable amount of time, say 7 days, to prevent attacks and to ensure that your systems are adequately equipped and not overloaded, etc. You may as well claim that you have a legitimate interest to keep those server logs, including the IP addresses, which are actually normally considered personal data, because it can be related back to you through an internet service provider, etc. You may claim your legitimate interest of processing that data. Then consent is one of the tricky ones, right? It's like if you use consent as a legal base, there are quite a number of requirements that you need to meet. It first of all needs to be freely given. Needs to be a real free choice for someone to give you consent. It is hardly ever possible to link this to the provision of a service. It's very hard to link this to for example, incentivization, etc. So consent is something that you really need to have a look at the wording and how the UX and UI is working around that, to really truly understand if the consent is actually valid, because it's only valid if it's freely given, and specific and informed. Specific means it's for a specific purpose. Just giving a blanket consent, yes, I consent to all processing of my data for all purposes, is never going to be valid, and it needs to be well informed. That means that anyone giving consent would basically need to be informed about, for example, who is the party collecting it, for what purpose is it being collected, how long is it being retained for, etc., etc. These things normally end up in a privacy notice or a privacy policy. And to go a little bit more in examples here, for example, promoted choice is very hardly, or can very hardly be considered a valid, or can be used to collect consent. If we think about the Facebook example, where the obvious option is to keep clicking the big blue button, and that automatically includes that, okay, yes, I agree to everything. And the other option, or say the more privacy-friendly option, may be grayed out or funny located or just not as obvious. One could well claim that this is actually not, there's no free choice here, because we are using these dark patterns of collecting consent. So that's absolutely something to take care of if you're looking at consent. Right, so what I just said, promoted choice, bundling, and illusion of choice, those are all things that we need to be very careful with. Subjects, like the data subjects, also have certain specific rights. The right of information, to be informed about what data is being kept, and how it's being processed. The right of access, actual access to this information that a company keeps about him or her. The right of erasure, underlined because it's specifically relevant in blockchain. We're getting to that in a minute. So basically have the right for the data to be deleted if there is no remaining valid legal base. The right of rectification, the right to data portability, for example, transferring data from one platform to the other, and the right not to be subjected to automated decision making, and the right to object to certain kinds of processing. These are all rights that are anchored into the GDPR, and not every right can be executed under every legal base and under all the circumstances, but to give you a general overview, this is what we're talking about. Right, and then the after this introduction, the point where we get to how personal data, blockchain, and self-sovereign identity relate, right? The first distinction that is important to make if we talk about blockchain, and this is often forgotten in many discussions regarding blockchain and the GDPR. There are different types of blockchain technologies, and they work very, very differently under the GDPR. The two main examples, public permissionless, the Bitcoin, Ethereum, etc., or the private permissions, the Hyperledger and most of the private chains that are set up in such a way, they have very different structures, and that the whole setup of GDPR is very, very different. And I'll explain that like with this example, right? And because the big question, or one of the big questions, apart from the right to be forgotten, that most people have heard about as a problem on the GDPR, one of the bigger problems, or perhaps even bigger problems, depending on how you look at it, is basically who is the controller and who is the processor in blockchain. As I previously explained, these are very distinct roles, and it is important to be specific about which role you take in an organization or in a setup. And if we look at a centralized environment, the example on the left, for example, where a bank is taking care of all the financial transactions as a middleman, it's quite clear the bank is actually the controller in this situation. They collect the data for their purposes with means that are defined by them. Now, if we look at the example on the right side, which is a more decentralized environment, this is definitely not so clear. So we can see the analogy with blockchain technology such as Ethereum or Bitcoin on the right hand side, where one party may publish a transaction to one node, that one node then spreads it amongst the network. There are miners that are actually verifying those transactions, implementing that, and then distributing the block, including those transactions, on a blockchain. Now, who is a controller and who is a processor in this situation? From my perspective, this is very difficult in a situation of public blockchain to define. However, in a private blockchain, permission blockchain, you can put some more restrictions in place. You can have contractual agreements around these kind of questions and around these kind of difficulties to more clearly define that. The other big challenge on the blockchain is the right to erasure and rectification. The right to erasure in Article 17 is definitely a problem under most blockchain implementations today. Looking at how do we erase something that has been written to a immutable ledger. Not a very simple task, if at all possible. However, saying that it is completely impossible is also not correct, because even in the original white paper by Satoshi Nakamoto for Bitcoin, there was already the notion of a mechanism called pruning that could actually prune old transactions to just reflect the more recent state of things in the actual blockchain, and that could potentially well deal with these rights. The problem is, like right now in nodes, it's not really implemented, and then there's still a possibility of someone running an archive node, and from that perspective, keeping all transactions and building a bit of an issue around the execution of these rights for data subjects. So one of the things that I forgot to mention actually is that many things on public blockchain are actually already considered personal data. So a wallet address or a transaction could well be seen as personal data, and should therefore be considered in scope of the GDPR and handled as such. So looking at some of the potential solutions or approaches to dealing with that, for example, encrypting on-chain personal data, could that be hypothetically a solution to the GDPR question? Could we, for example, just forget about the encryption key and move on with our lives and consider data to be forgotten? The answer is, it is unfortunately not that easy. First of all, encryption may be broken in the future. And encryption is a technical measure for the perspective of the GDPR, where the regulator says like, okay, yes, this is probably something you need to implement if you're dealing with personal data. And there has been some guidance already that if you don't encrypt personal data, you're probably possibly doing something wrong on some level already. But like storing personal data such as a name and an address and all these kind of things in an encrypted form on a blockchain is certainly not a solution, because it's not being seen as out of scope of the GDPR. It is merely a technical measure, and you will still not be able to comply to those two essential rights, the right to be forgotten and the right to rectification. Then what about hashes, right? And this is again like verifications of data, storing verifications of data in the blockchain, probably one of the best use cases for it, and very, very important in the architecture and the systems around self-sovereign identity. So if we create a hash of a certain data set, sure, we can store it in the blockchain. And if we take a certain document and we hash that and we put it on in the blockchain, or like on a blockchain, we include it in a block that's being mined and then included, then that is certainly not reversible. But there are some other problems with it. Now, if this is about a text or a verification of a document, there's potentially not that much of a problem in it. But let's look at a specific use case that is actually relevant under identity use cases, right? So let's assume I take the data from my passport. I hash the binary file of my photo plus my name, and make one new identity hash out of it. Then the question is like, is this something that I can actually store on the blockchain, because it doesn't directly contain personal data. However, the problem in this situation is that it could still be related back, and it could still be used in behavioral patterns to identify myself later on. Now, assuming you all know how hashing works, it's one-way encryption, and if I do this 10 years from now, take exactly the same photo and exactly the same data, make a hash out of it using the same algorithm again, then I end up with the same hash. And that's exactly where the danger is. Because going forward, I will still be able to, if someone gets hold of my passport or the data on my passport and runs that encryption again, is then able to refer my identity back to all the interactions that I had with the blockchain in the past. And that is actually where this relating back, this behavioral patterns, etc., could again lead to the identification of an actual person and could potentially be personal data. All very, very difficult, because these are exactly the things that we would want to do, especially in SSI use cases. But there are also some ways around. Now, there's actually not a lot of guidance on this subject, also because the GDPR just came into effect May 25th last year. But there's one piece of guidance that is especially interesting, and that is by the CNIL, the French data protection authorities, and they have published a paper thinking about solutions for responsible use of the blockchain in the context of personal data. And the file can be found here, but if you also Google for CNIL and blockchain, you'll end up on the same URL. But I think Alex will publish these slides with the links later on as well, if you want to refer back to that. Now, what the CNIL said, without going into too much depth, is basically something that in the first place is interpretation of the GDPR, and because of their jurisdiction in France, is also valid in France predominantly. However, these regulators in a European context tend to look at each other quite often and understand, okay, what have other regulators said, and how do we take this guidance? So far, this is one of the few pieces out there on blockchain from a regulator. So even in a more European context, this is probably the best guidance we have so far of dealing with personal data in a blockchain context. There are a couple of notions in there. For example, that a dApp developer, again, quite relevant under SSI use cases, a dApp developer could be considered a data processor. And that a miner could also be considered a data processor. Now, of course, like in theory, they deal with this data, but the question is also like, is this something as people in this specific space that we want to promote, or that we want to agree with, or is this something where we need to have other opinions? So there are quite a few things happening right now, and in Germany, I'm based in Berlin, and here in Germany there is an ongoing consultation going on by the Ministry of Finance and the Ministry of Economy around blockchain. That also contains a fair level of data protection questions, and I think it's very important that as an industry, as players in this area, we also need to make our voice heard and make sure that we don't create a situation where the use of any blockchain technology is outlawed right from the bat. Right, now those are some of the challenges in blockchain, but there are also quite a few opportunities of GDPR in blockchain, and those especially relate to self-sovereign identity. So one of the very simple examples is, for example, tracking of GDPR compliance. So for example, we can track an immutable history of events on the blockchain. Where as I said before, like consent is something that needs to be very precisely given, it needs to be informed, and there's a responsibility on the controller to always be able to prove that you have consent of someone, which is quite a burden. But blockchain technology can of course help with creating such an immutable record of events in the past. Of course, you need to be very, very diligent with that and make sure not to include any personal data on the blockchain while we're doing so. But still, by Merkle trees or hash trees, there are definitely possibilities of doing that in a privacy-conscious way. Of course, a record of processing activities could be another thing. The way that consent has been given and storing hashes of that may be very interesting. And there are a couple of other things that we can think about why or how actually blockchain could help with compliance to the GDPR. The other thing that could be really interesting to look at is alternative governance models, as I quickly call them. So basically, by looking at a system where perhaps nodes are being contracted, or there's a certain requirements for nodes to be in certain jurisdictions, and there may be contractual ways of enforcing rights, and also contracts that give some clarity on roles. Now, again, in a private permission setting, this is fairly easy to achieve by basically just making contracts a requirement in there. But there are also some more public or semi-public blockchain implementations. Think about EOS, for example. That even though you can put your question mark next to the centralization aspect or the purity of the decentralization there, this could, in a corporate setting or in a business setting, still be a very interesting approach to having a like, as far as it gets, a GDPR compliant blockchain. You can define who's actually the controller and the processor. Perhaps there's one central entity that is responsible, and the different nodes in this setup are being contracted to be processors. If there are clear written instructions, those roles can be defended in such a way. There can be contracts in place to enforce any rights, and nodes can be asked to blacklist or to actually forget certain data. And you can make sure that these kind of setups are only in Europe. So don't go cross-border, which under the GDPR is not impossible, but it just it brings up some additional problems if you cross the border, if you go outside outside of Europe, there are extra requirements. You need to do more due diligence and have different mechanisms in place to deal with that. Right. So with contracted nodes, there's a possibility to have this transparency, control, purpose limitation, data minimization, storage limitation by basically making sure that this is all in the contracts. Looking then specifically as the last point into self-sovereign identity possibilities, and what is important to consider is what is stored on chain and what is stored off chain, and who is responsible for personal data. Now, the on-chain and off-chain part is normally where there's the notion of your personal device or you yourself and your personal wallet keeping your specific personal data, but that verification needs to live somewhere on chain in order to be verified by anyone at any given point in time, right? Now, the question is still like, who is responsible for this personal data, and that is actually not that easily answered, unfortunately, in the context of GDPR. Now you can say, well, it lives on the user's device, so the user is responsible. There may still be, under the guidance of the CNIL, for example, there may still be an element where the developer of a certain app may need to take on some of the responsibility, or is actually under the GDPR held partly responsible for certain elements and certain processing activities. Also because it could be said that an app or dApp developer is actually giving an input mask and thereby defining the means of the data processing. And that could open up some liability. So these are things that definitely need to be very carefully considered in a self-sovereign identity situation. Right. The other technology that is very interesting, and that is also in some aspects in the realm of self-sovereign identity, is zero knowledge proofs. Wherever we can take an approach that we can minimize the amount of personal data that's being revealed, that is more than anything very much in line with data minimization principle under the GDPR. There's a high level of control over personal data if we can say, well, I only need to prove a fact with a high mathematical with a high likeliness of that being true, instead of showing you my actual date of birth or my actual age even. If we can just say that, okay, the only thing that someone needs to know is the fact that I'm over 18 years old to, for example, enter a venue or order a drink or whatever that use case is. So that definitely gives a lot of possibilities to create a more private world. Then, and I'm skipping that one, the GDPR and self-sovereign identity. What I think is a very important conclusion is that self-sovereign identity can be or become a very powerful tool for privacy protection. And as I assume you're aware, like, self-sovereign identity is one of those key center principles or systems in many blockchain ecosystems that enable a lot of different matters. So if we can start with a very good privacy implementation on this level, that is very powerful and very important to the rest of the ecosystem. There's certainly a visionary alignment with the GDPR. If we're looking at those principles again, we're giving people control, we give them transparency, and data is only being revealed on this need to know base. And both the GDPR as well as self-sovereign identity promote the free flow of data, but only the right amount of data. And this together can create this layer of trust and autonomy for data subjects that is very much required if we want to create a more private, a more user-centric world for our future. And what I'd like to close off with, very much in spite of that, is that where blockchain and self-sovereign identity may not be able to meet the letter of the law, do every single little thing, think about the right to be forgotten, etc., in exactly the right way. It may not be able to meet the exact letter of the law, but it can certainly deliver on the spirit of the law and potentially even overdoing on it. And with that, I'd love to open it up for questions, if there are any questions in the room. Anyway, yeah, sure.
Yeah, the couple that came up, I mean, usually they come up during the presentation. Today, they specifically said, "Oh, please ask this at the end." I mean, one that came up at the beginning, which I haven't seen it again, and I know the answer, but maybe you can explain it a little bit. Pierre was asking, "What is a DPO?"
A DPO, sorry, a data protection officer. This is a an official role within a company, and there are certain thresholds for that. For example, in Germany, any company that has more than 10 people involved in the processing of data needs to have a data protection officer, and this is a role that reports directly to the highest organ in the company, also the highest body in the company, and has also certain responsibilities towards the data protection authorities. So yeah, that's something that we do as a service, but a company can also choose to do that as a to basically appoint a separate position for that. That's also a possibility.
Excellent. We have Ivy, who's a regular guest, asking, how do digital exchanges, crypto exchanges, sorry, I just have to reread this. How do digital crypto exchanges meet GDPR compliance in the public blockchain space like Bitcoin, Ethereum, since they are methods that isolate transactions and then link them to an identity?
Yeah, I'm not sure if I completely understand, but I think where it's heading to is that exchanges. So you said digital or decentralized exchanges?
He's saying crypto exchanges only.
Good,
But
okay.
maybe you can explain the difference between the decentralized ones and the centralized exchanges for crypto.
Right. So right, if we look at centralized exchanges, then there are normally some financial regulations they need to comply with, and I think that's where this is headed. Is that normally those exchanges to allow you to exchange crypto and fiat money, they will need to perform a KYC AML, know your customer, anti-money laundering checks to basically make sure that what the source of the money is and to verify your identity. And of course, that exposes a little bit of your identity or your personal data, your personal information towards those specific entities, and that is in a way a little bit of the of a problem in the blockchain space, right? So we're looking at a decentralized system, and then for convenience reasons, such as exchanging money, we're re-centralizing certain elements of that. Now, these exchanges sit on large amounts of data that they can collect normally under the legal obligation legal base. And would need to deal with that. But of course, with that linking information that exchange then has, blockchain wallet addresses become pseudonymous. It's because there is a party that can actually link those blockchain wallet addresses back to identities. In a decentralized exchange setting, that is where there's more of a peer-to-peer exchange, and so far I haven't seen many of these procedures implemented in decentralized exchanges, but that is still a concept that is I would say at least experimental at the moment.
Okay, Ivy, if that question was good for you, please let us know. He just later detailed out that he was referring to decentralized exchanges. And then Ivy is also asking, how does it work in the USA and in Asia Pacific for those countries to deal with GDPR?
Right. So the requirements for non-European countries to deal with the GDPR are basically about what they are targeting. If they are specifically targeting customers or potential customers in Europe, then they are bound by the GDPR. Or if they have operations in Europe, like an entity over here, they are bound by the GDPR. Um, Now the question is perhaps a little bit like what defines that, and that could, like, for example, we could say, like, if a website, and like simple example, if a website has a German language version, why would you do that other than for the reason of targeting Germany and Austria and one or two other European countries? So then you would probably need to assume that you need to comply to the GDPR because you're specifically targeting this audience, even if you're outside of the EU. Now the question is, like, how are these things enforced? And that is a tricky question. But in general, there is the last resort measure that can be taken by a regulator is basically ban them from doing business in Europe, together with other regulatory entities. Yeah.
Excellent. Juan is asking, and hi Juan, he's wondering about level. Sorry, just many more questions coming in, and everything's moving. He's wondering about the right of data portability, and what level of interoperability does that require between competitors, and how would that be enforced? CryptoBridge, for example, he's asking, is an example he's sharing.
Okay, I can speak about that generally. I'm not aware of CryptoBridge specifically.
Oh, no, so yeah, he's just bringing up that he was referring to CryptoBridge as a decentralized exchange, so that's not related to, it was related to the previous question.
Okay, so data portability applies the moment that a company is engaged in processing data by automated means. The GDPR also applies if you would run a large, like a filing system on paper, then the GDPR also applies. But the right to data portability only applies, and I think that may be based on the legal consensus, or sorry, the legal base as well. But for automated data processing systems, that certainly applies. So, for example, I could request Facebook to export my profile in a common readable format, and that is the wording of the GDPR. Now, what that exactly means can be discussed. And then, if I would want to switch to this amazing platform, MySpace, that I've heard of, I should be able to import it right into my MySpace profile and exercise portability in such a way. Hope that answers the question.
Yeah, and Juan was just adding, for identity platforms, for example, if I have all my identity in Uport and I want to move it to Eurocom, would that work the same way?
I would assume so. I would assume, and that's actually a very, very interesting use case. I don't see why not. I mean, this is a very specific question and would need a lot of analysis, but I would assume that right would certainly exist. Yes.
Okay. One last question from Juan, just to add them all up. Can you talk a little bit more about the public interest authority case? Is that for police or news or what?
The public interest authority case. Sorry, I think I'm not completely getting that one.
Okay. Yeah, I don't. That's the same for me. For data processes, he's saying having access to personal identifiable information.
Okay. So how public entities or public administration have deal with data. So there are two different things. like most of these things with certain restrictions also applies to government bodies, to public administration. There are some more restrictions also because in that case it's very difficult to argue that that consent, for example, can be freely given if it's towards the government. Like what real choice do you have? So that may, for example, not be a valid legal base for them to process data upon. Now, in general, these things do apply to public bodies as well, with the exception for law enforcement. And I think there is, like, the GDPR is regulation 2016 679, and I think 2016 680 is the regulation around how law enforcement deal with this data, but that is organized in a different regulation, in a slightly different way.
Okay.
I hope that answers the question.
He will let us know. He's very active all over in social media. Is one last question, and I don't know if anyone else has a question, please bring it up. I have one more from Ifi. He's saying two questions that I'll bring up together. Can you explain more about SSI and GDPR and how they meet? And then he's saying also, and I don't know if you want to do that, if you can prepare another session where you focus exclusively on SSI compatibility or challenges with GDPR. So I think he's still hungry for more GDPR information in relation to SSI. So I don't know, maybe you want to outline a little bit the question about where SSI and GDPR meet and where it's relevant, the key points where it's relevant.
Right. Yeah, I think something like, let me answer the second question first while I think about the first one. I think this is something that may be very interesting to explore on a use case base. Look at a specific situation and then try perhaps in a debate kind of forum understand where the challenges are with a specific implementation. Like, as lawyers like to say, it all depends. So it depends a lot on the implementation, on, for example, how the structure is. Is there a certain app being developed, and there may be some caveats in the app. The protocol level is obviously something that needs some research, and that's what you will need to go into. So in general, I'd be happy to think about such a possibility, but I think it's a lot easier to talk around it and take a specific solution and look at it, look at the specifics, because a lot of details matter a lot for these kind of assessments and conclusions. Where they meet is, of course, where identity information is stored in a self-sovereign identity system. The assumption, and from what I know, most of the systems work in such a way that your personal information is actually kept on your device. So the first thing to think about is how is that storage legitimized? That is something that needs to be considered, and that can only be considered once you figure out who in this specific situation is a data controller and a data processor. And in the example of blockchain, you can actually bring in another example. So what actually happens if I, using the command line, insert a piece of personal data about myself in the blockchain? I create a transaction through the command line, and I'm not using any kind of input mask or software, or basically I write the code that transmits it to a node. Then who is the controller in that case, right? And the answer could well be, which is unconfirmed at the moment, but the answer could well be that I am actually the controller, and I'm also the data subject. So even though I do have rights, I may need to exercise them against myself, and that is getting to the area where there may be a little bit more freedom for people to do these kind of things. For self-sovereign identity, this is possibly also the area that we carefully need to start looking at to understand those relationships better and to better understand how we should deal with that in the best possible way. Just on my last slide about thinking about the spirit of the law and not the letter of the law. This is also where regulators have actually stated, not issued guidance, but stated that projects that actually do really well in the area of complying to the spirit of the law and the basic principles, there is some leeway for that. And I think these are the specific things, especially in the area of SSI, to further explore and to look into. Bit of a story, not sure if it answers the question, but I think this is the best short answer I can give to that.
I think it was pretty good. I think, one last question that just came in.
Sure.
Ian is asking, from a startup perspective, what would be the best way you would normally engage with regulators to ensure that you're compliant? Do you embed with the development teams during the discovery alpha design phase, or would you perform reviews once they have a minimal viable product, or would you offer training, or all of the above?
Well, if it's about involving the regulators, there's something interesting in the GDPR that talks about, like, the regulators are also meant to give advice and required to give advice and guidance on how to interpret these regulations. So far, I am not aware of many projects that have actually done that. I know of one project, and then basically they sought advice from the regulator. Say, well, with this and this party that we work with, we can't get a data processing agreement in place. And the response of the authorities was like, well, then here's a fine, right? So potentially not the optimal response, but this is something to be wary of. There are some requirements from seeking advice from the regulators if you engage in high risk processing of data, and there are a number of criteria using new kinds of technology, which blockchain certainly is one of them. And if you meet two or more of them, then you may actually need to seek advice prior consulting from the regulators. I would certainly involve a privacy expert in the design stage of a technologically advanced product that specifically deals with personal data. To meet the requirements of privacy by design, that is also anchored into the GDPR. I would not seek advice from the regulator until a bit later on, and until you can clearly articulate and have kind of like build a case around how you feel that you comply to the GDPR. Like, there's an accountability principle in the GDPR that I highlighted right in the beginning, and from that perspective, it is very important to build your own case for compliance. And yes, normally a privacy expert can help you navigate, like, what is more on the right side and what is more on the wrong side, and where do we need to find where do we actually need to find the prior consultation. But for the moment, I'd be careful with prior consultations until more is clear about these processes.
Yeah, sorry, I just misread the question. I think he was trying to refer, as you answered, that from a startup perspective, how you would engage with them, where you would engage, at which stage, which I think you answered already. But I don't know, you want to add something to that?
Well, depends on what kind of product. If it's so something with quite a bit of exposure to privacy, technologically advanced, I would definitely in the beginning seek at least a little bit of advice to see if you're on the right track, and then later on you can either be guided through defining all these things and creating all the paperwork, or you can of course also outsource that. But I would seek a little bit of advice right at the beginning. That would be my suggestion before you spend too much time into building something that cannot possibly be GDPR compliant.
Excellent. Special thanks from Ife. He loved your presentation. So just sharing
Great
that.
to hear. My pleasure.
And so if there are no other questions for today, Silvan, thank you so much for joining us today. For those that want to join future sessions, the next one will be happening the 1st of April with Philip Sheldrake from the Akasha Foundation, which is associated to the Ethereum Foundation. And he will be talking about identity and collective minds. And we had a very nice discussion in Barcelona during rebooting Web of Trust. And I hope he will be able to share all his knowledge and insights also with us during the next SSI meetup, which hopefully will be taking place the 1st of April, sorry. And yes, it will be same time as always, 1st of April, 9 a.m. European time CET, and different times for the rest of the world. And someone was complaining to me during rebooting Web of Trust, was Eric from Thailand, that these times are really, really bad for Asia, and I know, and I'm really sorry. But he was telling me that they're translating some of the SSI meetups to some other Asian languages so that people can listen to them and hear them. So that's good. And if possible, maybe we'll change the time in the future. Right now, just the best combination between West Coast, East Coast, and the European time zone. We'll see what we can do in the future. So thank you, everyone. If you want to check all the stuff out, we will be sharing it very soon and in the same blog post with the video, with the presentation and the Google Slides. If you want to listen to new SSI meetups, just join the Telegram channel, Twitter, newsletter, etc., all that stuff, and you will be updated there. And Silvan, thank you so much for sharing your insights about GDPR with blockchain and SSI.
My pleasure. Thank you so much.
All right.